Hi, everyone. Harry here to talk about the Supreme Court's most notable opinion released today, Garland versus Cargill, the so-called bump stock machine gun case. Okay, we're going to have to take a quick little lesson in machine guns and bump stocks. And I'm really the wrong guy to give it to you, but I'm what you got, and I think I can lay it out well enough to set up the issue. So a machine gun is defined just under the Firearms Act as a weapon that shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot, and automatically goes on to be defined. That is, you don't have to reload it by a single function of the trigger. So a classic machine gun is, Valentine's Day Massacre, or for that matter, October 7th. You get a gun, go, and it just, obviously that category, machine guns have all kinds of regulatory implications. A bump stock is basically a device. It seems like a fairly jerry-rigged, homemade type thing, or they can be more sophisticated, that make a semi-automatic gun, one in which, and otherwise you shoot one time to engage the trigger, into functionally a machine gun. So here is where I hope I won't mislead you too much, but basically, it sounds like, I've never done it, you get the gun, you have the bump stock on it, and you press just once. And I think you have to kind of get the motion down a little, but just your finger being there and the forward motion of the trigger and the recoil of the gun makes it into a deadly weapon that can fire 400 to 800 rounds a minute, depending on the gun. And most notoriously, there was possibly the worst shooting massacre in all time still in the country, 2017 in Las Vegas, where the shooter killed 58 people and wounded 500 in minutes, no time flat. And again, if you're looking at it, it is once you have it down. Okay. So the ATF after that had not previously categorized bump stocks as or semi-automatic rifles equipped with bump stocks as machine guns, on the ground that it's not a single function of the trigger. They recharacterized it here, and to clarify that bump stocks are machine guns. So you have this, it's a classic kind of Supreme Court setting. You have this very sort of dry antiseptic statutory text case that plays out against a backdrop of huge, human dimension, and in this case, mayhem. So you have 6 members of the Supreme Court, and Thomas, possibly the least abashed about the cruel result, just says, there is, for the reader, like 8 diagrams and a technical, possibly accurate, as a statutory construction case. It might be, bad facts make bad law, but we have all these diagrams that basically go to the point that the trigger moves for each shot. So it's very much riding on the notion of a single function of the trigger. And all these graphs basically serve to say, well, no, you're not pushing as normally. Your finger is basically just there, but the trigger in this sort of jerry-rigged way is able to basically go very quickly, and voila, you've got as the dissenters say, walks like a duck, talks like a duck. You have something that is indistinguishable from a machine gun, but their technical kind of manual and such says it's still more than one motion of the trigger for each shot. Alito, and so it's very sort of, straightforward, or dry, or bloodless, I think you could say. Now, Alito actually plays the Kavanaugh role here, kind of interesting to me, where he says, the Vegas massacre was terrible, but it didn't change statutory text, which we still have to follow. This is for Congress to do. And Sotomayor reads her dissent from the bench. That happens rarely, I would say. Maybe it's changed a little bit, but 5 times a term or so. And as these cases come to the end of the term, they are much more likely to promote reading of dissents from the bench. They fought a real brouhaha. The dissent has lost, and the sort of last gesture it can make is an impassioned reading from the bench that doesn't change anything, and there's nowhere to go, but is hopefully, public education and maybe a kind of bookmark for for a future court. Okay. So anyway, Sotomayor does her own little, firearms, primer. And then the core of it is as follows. This is not a hard case, says Sotomayor. All of the textual evidence points to the same interpretation. A bump stock equipped semi-automatic rifle is a machine gun because with a single pull of the trigger, a shooter can fire continuous shots without any human input beyond maintaining forward pressure. Okay. So, and she then says, I think this really is the nub of the matter. The majority looks to the internal mechanism that initiates fire rather than the human act of the shooter's initial pull, to hold that a single function of the trigger means a reset of the trigger mechanism. So I think that's right. I'm now setting aside the human tragedy of it. I think as a sort of bland exercise or bloodless exercise in interpretation, that really is the question. The majority is looking at the firearm and its internal mechanism, and the dissent is looking at single function of the trigger as looking at the action of the shooter. And in that sense, it's damn near a single function. Maybe you could have some philosophical or anatomical, debates, but basically you do this and it fires 400, 800 rounds. And now, of course, as happens in all these things, they cut back and on the administrative state interpretation, leaving what? As Alito says, Congress. So leaving, in a Congress completely beholden to gun interests, the hope of a bill passing, an unbelievable common sense bill that would say bump stocks are henceforth regulated like as machine guns are. We don't care about the nomenclature and what it says or the fine grained technical distinctions and diagrams, but that's especially in gun stuff. That's the tragic backdrop, is that even though majority of the country is for common sense gun regulation, and what could be more commonsensical than this, you have in the actual kind of political dynamics in Congress tremendous pressure by the gun lobby, etc. So the prospects for this very simple fix to pass, probably people would say, are remote. So you have a kind of a tragic day in a sense, but the court doing what it's not outlandish statutory interpretation. It's hard to say, because the ATF did reverse ground and won it. But I think the Sotomayor point, one of us is functioning on the trigger and one on the person, really is the nub of the matter. So there you have it. ATF slapped down, one of the Supreme Court's conservative majority's favorite things to do. and the next marauder can rig up a bump stock and create mayhem, at least until Congress changes the law. And for that, we can't hold our breath. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.